Welcome to the Mint Condition Podcast. This is Brad, and today we're interviewing Jake Lee from True North Injury Law. Thanks for taking time to be with us.
I'm thrilled to be here with you. Thank you for inviting me.
Yeah, absolutely. We're excited to hear about your expertise, kind of your journey, where you came from, and then hopefully give us some advice and how to get more providers helping people and answer a lot of those common myths out there about personal injury.
Okay, looking forward to it.
So with your practice, do you only work with personal injury? Do you do any family law or anything else?
Nope. Personal injury is all we do.
Okay. And personal injury, a lot of people think just car crashes, but anything with dog bites?
Yep, personal injury has a broad scope. I mean, it can even include workers' compensation, medical malpractice, all those areas. We don't do either of those things.
Okay.
We do car accidents, dog bites, bicycle accidents, motorcycle accidents, slip and falls, those types of things.
Slip and falls, what would that look like?
So if you, I'll give you a fax from a case I'm working on. I had a client who works for the post office. She went to deliver something at a house, and there was some ice that was covered under some snow that she fell on, and now $200,000 later, she's getting better. So she slipped and fell, and the property owner had an obligation to warn there was ice or to do something about it, and didn't, and so now we have a claim. So
just thinking big picture, if you're a property owner and you want to prevent that, throwing out salt, is that good enough?
Yeah, let's get into that. So property owners have a duty to warn of known and unknown dangers, okay? And they get 2 get-out-of-jail-free cards. One of them is if it's an open and obvious danger, and the other one is if they didn't have notice that it existed, okay? So, for example, most of the cases we have in Utah through like precedent with the court come from like Walmart and stuff like that. And I'll give you a really basic example of how these get out of jail free cards work. So let's say somebody walks into the store and they slip on snow or ice, and it had come from a snowstorm that had started 10 minutes earlier.
Okay.
There can't be any expectation that the store manager knows that it's happened and could have done something about it in 10 minutes. So they get out of jail free because there's no notice there, right?
So then who does it fall on at that point?
There you don't have any option at that point.
So then you're using health insurance.
You're using health insurance or whatever you want to do to go get the treatment you need. But in another scenario where it snowed yesterday and you have 3 feet of snow in front of your door and there's ice underneath it and I fall on it, you should have known there was snow, you should have done something about it, and now the injury is your fault.
Right. That makes sense. Any other things, we'll dive into more details on that, but any other things, dog bites, pedestrian
Dog
stuff?
bites, pedestrians, yep, we do both of those.
So, trucking
truck accidents, yep.
Okay, cool. That's awesome. So tell me your story real quick. Where did you go to school, and did you go straight into personal injury, or how'd you get here?
Yeah. So I did my undergrad at BYU, and while I was there, I was working for a personal injury law firm, and really grew to like it quite a bit. And
sorry, you said you were working there. What did you do there?
I had lots of roles there. I was the assistant to the paralegals.
Okay.
And then I built out the marketing department for this law firm. And then I decided to go to law school as a result of working there. And then when I was almost done, that law firm called me and said, "We want you to come back and work here, but we want you to open up a Social Security disability law firm." And I said, "I don't even know if I like Social Security disability." So I thought, well, I better figure out if this is something I'm interested in. So I went to Florida. I was going to school in California, and I went to Florida for the last semester of law school and clerked with a firm, a Social Security disability firm there, and learned and tried to decide if it was something I wanted to do and decided to give it a go. So I came back to Utah and built a Social Security disability law firm and grew that up, and I was getting ready to buy another law firm to expand.
Like you yourself or the group you were with?
The group I was with. Okay. We decided to purchase another one. And so I got into the books. I thought, well, this will be great for me to see what the next 20 years of my life is going to look like. And I wasn't real excited about what I found. So I convinced them to buy us instead and sold it. And went back into personal injury, and that's where I stayed. I really like personal injury.
So you went straight into opening your own law firm on your own, not with the same group anymore?
No. So what happened was collectively, I mean, they were the funders and I was the doer, right?
Yeah.
So I built that, and then once we sold that, I went back into work with them doing personal injury work.
Okay, cool.
Yeah.
How long ago did you open up True North?
And then we opened up True North Injury Law just over 2 years ago. September was our 2-year anniversary.
That's exciting.
Yeah.
So are you now on your own or still part of that same group?
Nope, this is me all by myself.
Cool. And tell us about your group. You got 50 paralegals and 500 buildings.
That's right. 300 paralegals, 25 buildings. No, so True North Injury Law, a lot of people like to give me trouble about the name. Like, oh, that's really cliche. I bet you spent a lot of time coming up with that. And I always want to tell them to shove it. But I did spend a lot of time thinking about it. And I wanted a name that spoke to our values, and I love the concept of the North Star. It's there, it never moves, it always gets you to where you need to go, and you can always plan on it, right?
Yeah.
And after a car accident, people are just overwhelmed. I mean, they're injured, and their car's not working, and they can't get to work, and they're sitting here going, I can't sleep, and they got insurance adjusters calling them and some making offers, and so they don't really know which thread to pick up first. And so our goal is to be the North Star for people in that case. It's to say, okay, here's the plan. Let's take some of this stuff off your plate. You go get better, and we'll meet back up in the middle, right?
Yeah.
And be the guide for people through that process.
I think that's so important because people don't know what they're getting into, right? They're thrust into this situation, like you said, very complicated, lots of things. But then they have insurance adjusters who know this game. It is their game.
Yeah.
Right? Do you play any sports?
No.
Okay. Instruments?
Uh-huh.
All right. What do you play?
I play the piano and the organ.
Okay. So you're going to join my orchestra.
Okay.
But we're going to have you play the violin instead.
Okay.
Kind of out of your realm.
Totally out of my realm.
What
Don't
is
have a
this?
clue.
Don't know what's going on, right? That's how I feel like people are thrust into this car accident stuff, and everybody around them knows what's going on and knows the game. They need somebody.
That's a great analogy. Great analogy. I mean, one of the common things we're seeing right now is a person will get in a car accident and they get a phone call 10 days later, and they say, okay, look, we will pay for your bills up to $10,000, and I'll give you $750. So just sign on the dotted line and you'll be good to go, right? And I mean, frequently lately, I have people coming to me saying, well, I got this offer on the table. I'm like, you put that offer on hold. Let's figure out what it takes to actually get you better, and then we'll revisit this. Like, well, they told me I only have 10 days to accept the offer. It's like, you have 4 years, take a deep breath. It's going to be okay.
Yeah, that's the frustrating part is when they're given that false information.
And false pressure.
Yeah. Yeah, and on somebody who has at least injuries, but maybe even a concussion, brain fog, things like that. Makes it way harder to process, and then you add fear, right? That's one of my biggest pet peeves in general in anything in the world, but especially healthcare. So we work with a lot of people in workers' comp, and they're told it won't be covered if you go there because the insurance has a contract with some other PT that they only have to pay half as much. So they're trying to force them to a different therapist. And hopefully that therapist still does a good job, but if they're taking half the reimbursement, then they're probably seeing twice as many patients per hour, right? Anyway, it's frustrating how that's legal or allowed.
Really frustrating.
Yeah.
And you get to choose where you go, right? Yeah. But they don't tell you that.
They don't tell you that. Yeah. They don't want you to know. So what have you done to help the community know about that, to know, like, don't take these offers? Do you have... How can we help more people to know that?
So we're doing a bunch of things. I mean, one of the things is our website. We're producing material all the time, trying to get that out there. When our clients sign up, we do a ton of education. They get all these videos and emails from us to try to make sure that they don't make mistakes along the line. And we're in contact with them frequently. But as far as the public goes, I mean, things like this where we can talk about it. I do a fair amount of speaking. Most of the time it's not to the general public. It's in continuing legal education or insurance education, stuff like that.
Have you done anything on social media, maybe some YouTube clips, anything like that? Get the information out?
We do some social media clips that we'll throw on our stories sometimes. We probably need to do more of that, but we're trying generally to help people understand what their options are and what are major pitfalls to avoid.
What do you mind sharing a couple, 2 or 3 of those pitfalls?
Sure, I got people? We'll call this the 4 things that you need to know about a personal injury case.
I like it.
So the first one is make sure you call the police in every single case. Utahns in general, we're just nice people. We
Yeah,
are, right?
it's true.
And people are thinking, I'm not that hurt. I mean, you don't look that hurt. So we'll just exchange insurance information and call it a day, right? Because they're thinking, I don't want to hurt you or do something to damage you because my arm didn't fall off, right? And then 10 days later, they get a phone call that says from the insurance adjuster saying, hey, we're denying liability on this case, so good luck. It's like, no, your guy told me he was sorry and that this was his fault. And I say, well, prove it, right? Well, there's no police report. There's no independent record of what actually happened.
Just he said, she said.
Exactly, which, that's what you expect in a court case is the plaintiff's going to be saying he did it, the defendant's going to say she did it, and there's no way to prove one way or the other.
Yeah.
Excuse me. So having an independent record makes a huge difference, right? So get a police report in every single case so you can document what happened. The second thing is don't say sorry. That's another thing is because people are so nice and, oh my gosh, I'm so sorry I did this. Many times they don't understand the dynamics of whether or not they're actually at fault for the accident, right? Yep. Or, they're just saying they're sorry because this happened, but it's interpreted later to mean that you're saying that you were, well, why would you say you were sorry if you didn't think you were at fault, right? Yep. And the third thing is you've got so much adrenaline going through your body that your brain is not really processing. You're just kind of reacting to everything. And it's not really fair for someone to take those comments out of context later when you're just reacting as things are happening to you. So don't say you're sorry. Do us all a favor and just don't say that, okay?
Yep.
The third thing I would say is take as many pictures as you can. Take them of the vehicles. Take them of your injuries, right? I'll give you a great example. We had a case where my client had about $500 in property damage, but she had $200,000 in bills, right? And so
like medical bills.
Medical bills.
Okay.
And the argument was, there's $500 in property damage. There isn't sufficient force in this collision to cause this kind of injury, right?
Right.
Well, the good news was we had a picture of the other guy's vehicle, and it was destroyed. And somehow my client's vehicle had just survived somehow, right? So it flipped that narrative on its head. It's like, don't tell me there's no force. Have you seen the other guy's car, right? But without those pictures, it's hard to make those arguments.
Yeah, that
right?
makes sense.
And the fourth thing I would say is go and get checked out. Make sure you go and see somebody. You have what's called PIP. That stands for Personal Injury Protection. In Utah, the law requires us all to have a minimum of $3,000 of personal injury protection. And so what that does is your own auto insurance policy will pay the first $3,000 of your accident-related medical bills. And lots of people one, don't know it exists, or two, they're nervous that if they use that money, their premium's going to go up, right? And the truth is it won't. In Utah, as long as you're not at fault for the accident, your premium's not going to go up for using that PIP money.
What if you are at fault?
How
does that affect it?
So it's called no fault insurance, right? So because you're at fault for the accident, your premium's going to go up anyway, right?
Because you caused the accident.
Because you caused the
So
accident.
using that PIP doesn't change that one
is
way or
irrelevant to the point.
Okay,
yeah.
cool. That's super helpful. Now, you said go get checked out.
Mm-hmm.
Obviously, as a physical therapist, I'm going to say go to us first.
And your primary care physicians now, right?
Right. That's right. Here in Utah, that's changed. But what would your advice be? Who's the best first stop? Urgent care, ER, chiropractor, PT, MD?
I think it depends on the scenario, right? I mean, if you are very, very seriously injured, get in the ambulance and go to the hospital, right? Okay. If you don't think you're injured enough to take the ambulance, okay, but go see somebody. And the reason for that is, in my world, if it's not in a medical record, it didn't happen, right? Yeah. And what happens down the road is, well, you're reporting all these symptoms, but if you actually had them, why didn't you tell anybody, right? Yeah. So it becomes very hard for us to prove that symptoms are connected to the accident if we don't have it documented. And I mean, I don't love ERs, but for the purposes of trauma, that's one of the only options we have. But the reason I don't love ERs is things don't get documented very well. And I'll give you a classic example. You go in and you're experiencing concussion symptoms, and they do a CT scan, and because there's not a brain bleed or something like that, you don't have a concussion, right? And then 5 days later or 10 days later, they go see a concussion specialist, like you clearly have a concussion and it's diagnosed. So if you didn't go to that specialist 10 days later, all we have now is a medical record that says you don't have a concussion, when in truth, your symptoms don't match what's in the record. So I don't love ERs for that reason.
But that's great advice for all of the clinicians listening, right? That your notes matter a ton.
Oh, to be sure.
So one of the big pitfalls for physical therapists is they'll put MMI, max medical improvement, right? That when the patient's still 80% better, what they mean is met the max they can reach with PT. They need pain management or something else. But you just hurt their case. Same thing with the ER. These ER docs have so much going on. People maybe, you come in with a concussion, they scan, you're fine. It's not life-threatening. They're moving on to something life-threatening. It's like you're hurting a patient by saying they're fine. Don't say that. Just say, no, they don't have this top worst-case scenario, but it could be any number of other things. We've referred them to their MD. Leave that door open instead of just slamming it shut.
That's a great point. And it takes me to something else I'd really love to talk about, and it's the collaboration between providers. The worst thing a provider can do is take the attitude that I am capable of fixing all of your issues, right? I can't tell you what a difference it makes in a case when a provider's willing to go, I'm not exactly sure right now. The picture isn't super clear. So let's try these things, or let's go get an MRI, or let's have you visit with my pain management doc over here and see what these people have to say, right? Because I think any honest medical provider is going to readily admit, I don't know about brain surgery. Right? I mean, let's say you're a neck surgeon. Well, you don't do brain surgery, right? Or a foot surgeon doesn't do physical therapy. And so the more collaborative you're willing to be, the way better outcome it is for the patient in terms of physical results, right? But for the purposes of the case, you're creating a really powerful bulwark around the case. And the reason is, I'll give you a really great example, is if I've got one doctor and the defense hires 3 doctors on the other side, just in terms of sheer numbers from a jury perspective, it's like, well, I got 3 credentialed people who are saying that this plaintiff's full of crap, right? But when I've got an ambulance visit and an ER doc and a physical therapist or a chiropractor and a pain management doc and a surgeon, now it's like, okay, well, you're saying that none of these injuries either exist or are related to the accident, and I've got 5 people who actually treated the person, who have reviewed the imaging, and they all agree that the treatment is caused by the accident and was appropriate, right? And you just can't create that kind of power out of a single thing, nor do you get the same kind of outcomes.
Well, and you get all of their evaluations earlier on, where someone else isn't really looking at that patient, maybe an IME or something, but they're just reading documentation. And so eyes on early on. That's one of the big things that we're trying to push for, is getting any provider out there to get everybody involved from the beginning. Even if you're not going to do pain management day one, have them do an evaluation. Have the PT, have the MD, the chiropractor all do an evaluation that first week or two, so that we see them at their worst. Often with PT, they work with an MD and chiropractor for 4 or 5 months, and then they come see us, and they're 60% better or they're 80% better. So our initial evaluation says they're doing pretty good.
And I think my response to that is, I try not to be in the space of directing care, right? That's not my role. I'm not medically trained, right? So I defer a lot to the good judgment of the people that I trust and work with, right? And if we get to a point where you clinically are going, yeah, this is very appropriate, like we've hit a point where we need some additional insight, or let's try some injection therapy and pair it with the physical therapy and see how that goes. Because as you know, we get injection therapy, we're able to decrease the inflammation, and now we can get back to this motion is lotion type thing, right? And it makes a huge difference. But I would defer to you guys in terms of when you think it's clinically appropriate to get somebody involved. And there's nothing better from an attorney's perspective than when I have the ability to call you up and say, hey, I'm concerned about this and this. What do you think the options are? And now I'm not the one directing the care. I'm just expressing the concerns I've heard from my client.
But that just gets the best outcome for the patient.
Yes.
Because there are lawyers that I've talked to who won't even do that. They're like, we file the paperwork, we handle we stay in our corner, which is great that they're not directing medical care like what you're talking about. But work as a team. Reach out. The patient and patients will tell the lawyer one thing and tell the PT something else and tell the chiropractor something else.
Well, and it's a huge disservice to your client from an attorney perspective, because I wouldn't want to go to somebody who has no interest in communicating with my providers, because the lawyer knows what the defense arguments are going to be and what problems they're going to run into. And if you can communicate with the providers and say, hey, I know this is coming down the pike. What can we do about that? Or do you see that as a problem?
Right.
Now we're able to stave off a whole bunch of problems down the road that would have substantially devalued the case.
Yep. And that makes sense. Often as providers, like you said, we think, I can fix everything. I don't need that MRI. Especially physical therapists, we're known for being conservative, right? On treatment and not getting MRIs. But the MRI isn't necessarily always just for treatment, but to support objectively the symptoms and the findings that we're seeing.
Yes. One of the things physical therapists, I think, do super well is you guys have all these objective tests to measure range of motion and strength and all this stuff. And I love that because your notes always have good stuff that I can use when I'm arguing. But those tests aren't always definitive in terms of whether we have an annular tear, right? That's the tear is causing this bulge disc, and now that's impinging up against the nerve root. I mean, a straight leg raise test can tell us we probably do, right? But until I can see it on an image and then go and explain to an adjuster, like the annulus is avascular largely, right? So it's not going to repair itself. We have this permanent tear, but I can't do that with just objective findings. So, just those specific tests, right? But having an image, now I have a whole new set of arguments I get to make, and that makes a big difference for the client.
Yeah, and I've heard from several people that even if the MRI shows there's nothing wrong, that's still good. Is that true, or what have you found?
I mean, we need to know one way or the other, right? So if things are in good shape, awesome. Now we know. But one of the hard things is when clients are reporting a whole bunch of symptoms, but we're not seeing anything on the imaging. We need to know that, right? Yeah. Because they may be in there reporting all this stuff. It's like, well, they probably have this and this and this and this, and now I've got an MRI. It's like, we don't actually have any of those things. So it puts me in a position where I can set the expectations of the client in a different way.
That makes sense. I like that a lot. What advice would you give clinicians on the best way to build that communication, build that network so that happens more?
Yeah. I mean, sometimes what I'll do is I'll just reach out and say, hey, I don't know you, but I understand you're treating one of my patients or one of my clients, and I would love to get to know you and see how we can work together to get the best outcome here. And you'll get some people who will tell you to pound sand, like, I'm not interested. It's like, okay. And
what makes them not interested? They're not interested because they just don't care about auto accident, or they're like, I fix the patient, you'll get what you get.
I think in their mind, they've had enough lawyers who are trying to direct care or tell them what to do that they're just like, I don't want to do this. I don't want to be deposed. I don't want anything to do with this case. I'm going to treat the client, and that's all I'm going to do.
That's fair.
And, I get that some people who aren't, maybe this is unfair, I'm painting with broad strokes here, but there are some people who don't want their work subjected to a spotlight, right? And you have to know that if you're working in personal injury, you may be deposed, right? And you're going to have to defend your work. And it's clear as day when you meet somebody who's like, yeah, the science shows this, the medical literature shows this, and we're in good shape with what we've done, versus someone who's like, I don't really know, but this is kind of what we do. So you can always tell pretty fast whether or not you've got somebody who's defensible. And those people usually have no problem with their work being scrutinized.
Well, and I try to educate, because we have a lot of students that come through our clinics, and I try to educate them that you could get deposed on any patient, right? With auto accident, maybe it's more likely because they're trying to prove fault and who pays. Mm-hmm. But you treat a Medicare patient and you injure them, now it's malpractice. Now you still might get deposed in telling your story. Mm-hmm. You've got to be able to defend your work as a professional.
Yes, absolutely. And I think that goes to a sub point, which is super important, is what's in your records, right? From both a malpractice standpoint and from the personal injury standpoint, if you're offering testimony that's not in your records, it feels like you're making it up for your own purposes, right? It's like, well, we did this and this, and I showed this. Well, why isn't that in your record? well, I didn't think it was appropriate or necessary because it's so obvious, right? It's like, well, it's not obvious to anybody but you, right?
Yep.
So for the purposes of personal injury, I mean, having a causation statement in there can make the world, can change the night to day. Okay?
Yeah.
Because if there's not a clear understanding that this person's symptoms and their injuries are directly tied to the accident, and maybe 3 years ago they had a similar injury, it makes it really easy for the defense to say, well, this is just leftover stuff from that. It's like, this person's had a clean bill of health for 3 years. They haven't had any symptoms that's led them to get treatment. And now you're saying this is leftover? Well, the doctor didn't say anything about it. So he clearly didn't think it was tied to the accident.
So it's left up to you to say, come on, guys, seriously, we're making that? And you don't have much to stand on. But if the
I don't have anything to stand on.
Yeah, but if the doctor puts that in there, that causation clause, then you have a lot more to stand on.
Yeah.
According to this medical provider, that's the case.
And I think a lot of medical providers feel pressure from us to say that everything's related to the accident. Right. And that's not where I, or really any of my colleagues, at least the ones that I like, are coming from.
Yeah.
Because if there is a pre-existing something and this person's been receiving treatment, great. Tell us that. Like, I think 90% of these symptoms and injuries are tied to the accident. 10% of them aren't, right? That's something I need and want to know. The other thing I need and want to know is if you're treating somebody who it's like, you know what they're telling me does not add up with what I'm seeing here. I want to know that too, right? Because the last thing I want to do is put a client on the stand who's completely indefensible and then have them have some expectation that something's going to happen, right?
Yeah.
So the relationship between the provider and the attorney can save us all a lot of headache.
I think that a lot of people are afraid they won't get paid. So they try to not include things or blame it and I like what you're saying is it's okay. Just tell the truth.
Tell us what it really is.
Yeah. What are we seeing here? What do you think? What I can imagine as a provider, them saying, what are you basing that on? Right? 90% is from this new accident, 10% from previous. The new accident aggravated previous conditions. How would a provider defend themselves on something like that?
That's a great question. I'm going to dive in a little bit here and tell me if this is more than you want to know.
We want to know it all.
Okay. So when we disclose an expert in a litigation setting, we have to prove what their opinion is based off of, right? And Rule 702 of the Evidence Code talks about your training and your education, right? So that by itself forms a foundation for your opinion, right? Yep. The next step is, so your training and your education and your experience, right? You can go to school and read the book all day long, but getting in and having some hands-on experience makes a world of difference. I'm sure you'll agree with this about how you understand the theory that you've been learning in school, right? It's like, we learned this, but this is how it actually translates into real life. So those form the foundation largely of where you're coming from, right? Now when you can add on top of it medical literature that supports your stuff, what I'm starting to see from a lot of providers is they'll put in the footnotes literature that they can refer to later in their notes. And that's part of all of their records now, right? But what they know in advance is when we have a straight leg raise and we think that there is a bulging disc or something like that, these 14 articles support that this test shows us this, right? And now when you walk into deposition, not only is it just, well, this is what I think. Well, what's that based on? It's based on my education, my training, my experience, and a whole bunch of other people who have authored these articles who agree with me. Right. And that is a really powerful place to be from a provider standpoint. So I get that you guys are in journals, right? There's things you do to keep up on top of things. But, as you find stuff that's useful, cut that stuff out and save it in a file somewhere. And that way, when you get into deposition, you got stuff to back you up. It's not just, well, I'm the one person in the world who thinks this. There's a whole bunch of people who agree with me.
So when you said that some people will add that in, is that a good thing to add that in with your bills and records on auto accident cases, or just have it in a file somewhere that you could reference later?
I think either is good, but I also think having what people will do is they'll put it in like a footnote at the bottom of their record, and it's part of the template.
Yeah.
And so you've got footnotes 1 through 5 on this type of diagnosis or something like that. And so now, regardless of whether you disclosed it this is more complicated than we need to get. Regardless of whether it was disclosed as part of the expert disclosures, it's part of the medical record.
Right.
So we've got it one way or the other.
Yeah, that makes sense. That's something that we need to do better at in general, but a lot of providers I've talked to try and educate more people in our community to get involved because I don't see this as we need to compete. I don't want to compete with chiropractors. I don't want to compete with other PTs. I want them all involved because people need better care, right? But all of them I've talked to, they just feel overwhelmed by that requirement.
And I get that. And that's why I made the point I did that you guys are reading these journal articles anyway, right? Like you're all working and you have to do continuing education to keep your licenses, right? So as you come across things that help, what's the word I want? That demonstrate the efficacy of what you're already doing, hold on to that article, right? I mean, there's no reason why you need to go spend 20 hours a week doing medical research to put yourself in a place where you can defend your work.
Yeah. I think that's so important, and it will help people have more security. What would be your message to any providers out there that aren't getting involved or haven't touched auto accident cases, or they're afraid to hold a lien? What would you want them to know?
I want them to know that please come to the table, right? I mean, we're moving into an era in personal injury that's becoming increasingly difficult. And because of that, there's more people who don't want to get involved. But there is a whole world of people out there who really need good, experienced, educated help. And if you choose to stay out, you're putting these people in a position where they have to choose from bad options.
Yeah.
Right? We need you.
Yeah, there's a lot of money in auto accident world, and so there are some groups that are, I don't know, it feels like don't have the patient's best interests at heart.
Let's say it like this. If the primary motivator for what you're doing is the bottom line, and I'm not going to throw out platitudes like we're not all here to make money. Of course we are, right? That's why we work. We need to make money to survive. But when the primary motivator for what you're doing is I need to see 75 clients a day in order to hit this mark, and that drives everything you do, you start to cut corners, right? But when it's about trying to get good outcomes and you build a reputation for somebody who gets good outcomes, that person is largely unimpeachable.
Yep. Yeah. I like the way you said that. Focus on, if that's your focus, everything else falls into line.
And these big companies who have outside money, or it really is just a business model, those people cut corners all the time because it's hard to make money or as much money or pad their margins in the way that they want to. But people who do great work, it speaks for itself, and it's kind of synergistic. It's like, hey, this guy got me better, and I didn't have to go for 12 months, and go see him, right? Like it speaks for itself.
Yeah. It really builds that reputation and that following. What other things do you see in your daily practice that maybe the public doesn't realize, maybe other providers don't know, or your clients, people who are in car crashes, don't realize?
Well, I'm going to talk about something that you probably didn't intend.
That's all right.
We've got tort reform coming our way. Now, for everyone who's going, I've heard that word but have no idea what it means. A tort is essentially a personal injury claim. So tort law covers the umbrella of most personal injury stuff. Okay. It includes some other things, but for our purposes, that's what we're going to call it. And tort reform is where they're trying to limit what you can do with a tort. Okay? So in places like Georgia and Texas, in Georgia just this year, there was a devastating law passed that put caps on what you could get from a personal injury case. It required the disclosure of health insurance, and people are going, well, who cares about that? There's something called billed versus paid, okay? And so to give you an example, let's say you bill $300 for a date of service, right?
Yep.
And the reimbursement rate for that is $50. And, right?
Okay.
So I'm just throwing out numbers. Right. So what happens is the defense is arguing, well, Brad only got paid $50 for this, and my client's only responsible for the damage they caused. So he should have to pay only $50, not the $300 of the visit, right?
Right.
Now here's the catch on that. It's a really nice soundbite, but here's the catch. If you have medical health insurance, their reimbursement rate might be $5. And so the amount of money going into the client's pocket increases because what the reimbursement rate is lower.
Right.
But someone else who has bad health insurance, right, where maybe they pay $50 of this $300 bill. Right. Now that person gets a lot bigger settlement.
Yep.
Does that make sense?
Yep.
So the fairest way to do this is to say, you know what? The defendant doesn't get the benefit of my choices if I've planned well to have good insurance, right?
Yeah.
The fairest way to do it is everybody gets their bills paid for, whatever they cost, and we're not going to discriminate between whether you can afford good health insurance or whether you can't.
Right.
Right? But what it did is it created this bill versus paid thing in Georgia, and so now they can only get the reimbursement rate that the health insurance pays.
Depending on their insurance, so it's different with each person.
Exactly. The other thing it did is it required lien disclosure. And right now, up until this 3 months ago, we didn't have to disclose liens. And the problem that creates is in Utah, I'll give you an example. The case that just came down says that anybody who holds a lien is an investor in the case and has a financial bias in their testimony.
Okay.
And so in Georgia, what we're seeing happen is they'll put somebody up on the stand and say, well, we can't rely on what you're saying because you have a financial interest in the outcome of this case. So you have a motive to lie. What doctor is going to put their license on the line to get paid in one case?
Yeah.
Nobody, right?
Nobody. It doesn't matter if it's $5,000 or $50,000.
It's insanity. And so the problem is if these laws are allowed to pass in the state of Utah, it's going to drive great doctors out of the practice. It's going to substantially reduce fair settlements, and it kind of limits what a jury can do. I mean, the whole point behind a jury is that the people in the community get to decide, well, if damage like this happened, this is how responsible you should be.
Right.
And what the legislature is doing is say, we know better than you, the people, and we're going to decide how much a case is worth. And that's not how the Constitution was set up.
Right.
Set up that the jury, the people in the location, because, care costs more in California or New York than it does in Utah.
Yep.
So people in the community get to decide this is how much we think something like this is worth. And so the free market really reigns in a jury trial.
Yeah.
And when you have tort reform, it messes all that stuff up. So I want providers to know and the public to know this stuff is coming down the pike. And I'm not aware of any legislation that's pending right now, but we got a dose of this last year. There was a medical malpractice bill that was trying to to limit or eliminate the ability to make a medical malpractice claim.
Yeah, I heard about that.
Right, and it turned into a very acrimonious fight. And ultimately what happened is they were able to put a cap on what a medical malpractice claim can recover. But
so no matter what
the circumstance is, you're limited to the cap's $1 million. And the theory on the defense side was, well, I mean, $1 million, that's crazy. You're winning the lottery if you get $1 million, right? And that's driving insurance premiums up. And so it's driving good doctors out of the state of Utah because nobody wants to pay those kinds of premiums. But on the other side, I mean, I'll give you a great example. I had a case I worked on several years ago where a man was hit in a head-on collision, okay? It caused a brain injury. He had medical bills well over $1 million, and he had a horrible brain injury, and the man will never be able to work again. And he was in his early 40s. So he has 25 years of life left to live, and his care on average, just like regular physical therapy he needed and the emotional and psychological stuff that he needed, it equaled out to about $200,000 a year.
Wow.
Right? So if you add that up, if at $1 million cap, you get 5 years of care.
Yep.
And essentially what that law is saying, we don't care about your life after 5 years.
Yeah.
You're going to get $1 million and that's it. That's not justice.
No.
And that's not fair.
And they think you won the lottery. You didn't win the lottery.
No.
All that's going just to your care.
I'm not going to
try
Disneyland. I don't live in a luxury mansion, right? Like what I'm doing is I live in this tiny house. I can barely make my expenses, and that's it.
Yeah. For 5 years only.
Yes.
Not even the rest of your life, just 5 years.
And so that's why I'm kind of shouting this from the rooftops right now is it's happened. We saw that devastating bill pass in Georgia. Similar legislation has been introduced in Texas. We're seeing it in Denver, in California, and Nevada. And so it's only a matter of time before it gets here. Yeah. So as you hear about this stuff in the news, go out and talk to your legislators and let them know how bad this is for the people in Utah.
So send a letter, send an email. tell your legislators you're against that.
Most people think that their voice doesn't matter very much, but what they don't know is let's say I'm calling somebody from another district.
Right.
Those people don't want to hear from me because I don't elect them.
Yeah.
I elect the guy in my district, right?
Yep.
So they won't even take my phone call or read my email. But if you're in the district of that person from the House or the Senate, they will hear you out.
Yeah.
And so you can have a lot of influence. I mean, people think that I'm just one voice. Well, if they hear from 3 or 4 people on a specific, it's like, whoa, there's some real interest in this, right? They hear from 100 people, it's like, holy shit, this is huge. I need to act on this, right?
Yeah, they might have thousands and thousands of people, but I think it adds benefit to that they don't hear from people on every single one. So on something where they do, it stands out,
exactly.
Right? So that was a big thing with physical therapists becoming primary care providers, was hearing from just a couple people, hearing from PTs, obviously, but even a couple MDs that were saying, like, we're overwhelmed. Our patients are waiting 6 months, 9 months to get in here. Mm-hmm. And that made a big difference. What I saw on that process was anybody from the public could speak up. Like, you don't have to be an MD, PT, a lawyer to show up to the Senate and they say, anybody have any other comments? You can say, yeah, my daughter died from this surgery, and fortunately it happened before you guys were trying to screw everything up.
What everybody doesn't know is those guys would prefer not to hear from us. They want to hear from the public.
Yeah.
And so they have what's called a committee hearing on a bill, and anybody can show up and testify. That's what you're doing, is you're offering testimony. So they'll say, who wants to speak on this issue? You raise your hand and you go up to the pulpit and you get your 2 minutes, right? Yep. And what we did is we organized regular people who had been injured to come up and talk about how this bill would affect them.
Yeah.
And that was powerful stuff. I mean, it took it from something that was just a train we couldn't stop to a whole bunch of legislators going, whoa, maybe we need to stop and think about this for a minute. So the average person needs to understand how much impact they individually can have if they will just show up.
Yep. And what makes it difficult is you don't know it matters until it really matters, right? We were just a part of the MAD event.
Okay.
I've always been a big fan of the Mothers Against Drunk Drivers and what they do. And the families there that shared their stories, it just breaks your heart. And some of them, it was 6 months ago. Some was 3 or 4 years ago. And they're like, we heard about these stories. We knew about this, but it was like, oh, well, it won't happen to us. And then it did. So I think the public's got to get out, pay attention to these things, because it doesn't matter to you until it does.
Right.
And then you're the one who has a botched surgery and you're hung out to dry.
Yeah. We have this problem societally where we kind of bury our heads in the sand until it applies to us.
Yeah.
And you heard that saying that, and this is a little bit dramatic, but you heard that saying that came out of the Holocaust, that it was, well, they rounded up all the political opposition, and I wasn't one of those, so I didn't say anything. And then they rounded up the gypsies, and I wasn't one of those, so I didn't say anything. And then they rounded up the Jews, and I wasn't one of those, so I didn't say anything. And then they came for me, and there was no one left to speak for me.
Yep.
And that is so true. Like, you're hoping someone's going to understand, like, oh my gosh, this is coming for me and I need help.
Yeah.
And until it hits you, you don't realize how important it is that other people speak up. So we need to do that.
Yeah. I think that podcasts like this are a good way to get that information out there and get people to say something before it applies to them. And maybe it never applies to them, but their voice still matters.
Yeah.
That's cool. I like that. Well, anything else you want to fit in? I've got a final question for you, but anything else you want to cover? Any message you want to get out to our public?
I think that's a primary message I want to get out is this is coming, be aware of it, and we're trying to be at the forefront of this conversation so that people understand what impact it's going to have on them. So lay your question on me, Brad.
Yeah. Well, real quick, to add to that, how can they find more information?
Yeah.
When it's coming, timelines. If they're like, how do I help? What do I say? Can they call your office? I'm sure you guys don't want 1,000 calls, but what's the best resource for that?
Yeah. So when stuff like this happens, it's almost always in the news. And the time frame is right around when the session starts, which is usually about January 20th, is where you start to see a lot of this stuff start to percolate.
Okay.
Because it's what happens is the bills go through a drafting process and then they get released publicly.
Yeah.
And so until they get released publicly, the press doesn't know what's going on, right? So around that time, you'll start to see a lot of things percolate. So that's a time you want to pay attention, right?
Okay.
And I serve as the chair for the legislative committee for the Utah Association for Justice. So if people want to reach out to me about this, that's actually awesome. I can
Okay.
direct them for who they need to talk to and all that kind of stuff. And that I would be a great resource.
That's fantastic. What's the best way for people to contact you?
So if you're injured, call us at 801-849-3664. But if you want to talk about legislative issues, call us at that same number and
Okay.
they'll direct you over to me.
That makes that easy.
Yeah.
And then website, just True North Injury Law.
TrueNorthInjuryLaw.com.
Okay,
Yeah.
terrific. So final question for you. We ask everybody this question. What does mint condition mean to you?
Best possible condition.
Okay.
Brand new.
So whether it's a car, your own life, whatever.
Yeah. I mean, I'm thinking of a coin, right?
Okay.
You're minting a coin.
Yep.
And when it's in mint condition, it's just been freshly minted.
Yeah.
Right? So it's fresh out of the chute. So I would say that's it. So whether it's a car, it's in almost brand new condition,
Yeah.
right? That's what I think mint condition is.
I love that. Well, thank you so much for taking the time. Come out, share your experience, your knowledge. People need to know that they have resources. If anybody is in a car crash, free consultation to call you. It costs $500,000 to call you. How does that work out?
$10 million up front. No. So what we do is we offer completely free consultation. And lots of people in Utah, because they're wonderful people, are going, I don't want to sue somebody, right? Like I'm nervous about that. And what I tell everybody is this is a completely free consultation. Come talk to me and let's see even what your options are. And then you can decide what you want to do. And then we work differently than many other lawyers. Lots of them bill hourly. And we work on a contingency fee basis, and what that means is you don't have to pay unless we get a settlement. And so you're not putting yourself at financial risk by coming and talking about what your options are.
Yeah, they're not in a contract with you. Even they can talk to you, get some advice. The two
They
things
are in a contract, but they can call us anytime and get advice because it doesn't cost them $250 every phone call.
right, exactly. Well, I mean, like even before the contract, where they could call you and find out if you're the right fit for them.
Yes, and that's important. I mean, go and talk to somebody. I mean, lots of stuff's done over the phone these days, and I'd say, look, there's going to be a lot of ups and downs during a case. Go sit down with this person and find out if they're a good fit for you.
Yeah, I'm a big fan of that. We tell them that with physical therapy. Come and interview the PTs here. Interview them as if you're hiring them, because they are. And then the second thing is I just wish more people, I love that people in Utah are so friendly and don't want to, hurt somebody else. Or like you said earlier on, I'm not that bad off. I'm fine. But you have adrenaline rushing. You don't actually know how bad off you are, or you're going to get blamed later. Just get advice. Talk to a lawyer if you are in a car crash, one way or the other.
Yeah. And I think what I would add to that is we are friendly people, but we believe in accountability. And that's why insurance exists. We're not taking this person's house. What we're doing is there's insurance that exists because mistakes get made, and that allows us to pay for the damage without having to go bankrupt. And so you're not doing anything to hurt the other person, but what you are doing is putting yourself in a place where you can get better, and it shouldn't cost you money to do that.
I love that. I really appreciate that. And this is really good advice for everybody. So thanks for taking the time.
Thank you. Good to be with you.